We are recording.
All right. Good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Elgo and Judge Abrams on the matter of Francis Anderson versus the Commissioner of Correction. Docket is AC 43455. This argument is being conducted over the Teams platform, so everyone is appearing by video conference. In addition, the argument is being live streamed on the branch's YouTube channel and will be posted later on the branch's website. Because it's being live streamed, I would remind counsel that to the extent there's any protected information involved in this case, please do not disclose it or mention it during the course of the argument. I'm going to start by asking everyone to identify themselves just so we can make sure we can hear and see each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
Morning, Judge Elgo.
Judge Abrams.
Attorney Jay Sexton.
Attorney Janelle Medeiros.
All right, I can hear and see everyone okay. I assume that's true for everyone else. If at any time during the proceeding you are unable to hear anyone, let us know. If you're unable to see anyone, let us know. And if you get disconnected from the conference for whatever reason, please go back to the link and try to rejoin. We will suspend the conference until we know that we have everyone present. We're going to ask everyone to keep their microphones muted when they're not talking to avoid any background noise or people talking over each other. If the judges have questions, we're going to raise our hands and ask that you recognize us again so we can avoid talking over each other. If you do not do that, if you're happening to be looking down at your notes, we will jump in like we would in the courtroom, but we're trying to avoid doing that. While we ask that your microphones be muted at all times, we would ask that you keep your camera on at all times so we can make sure everybody is appropriately engaged in the argument and is still present. I would remind everyone that although we are all doing this from locations outside the courtroom, this is in fact a courtroom proceeding, and we expect everybody to observe the same decorum that they would observe while in the courtroom. Not the present counsel, but we've had a couple instances in the last couple weeks that have been somewhat surprising to us in terms of how counsel conducted themselves from their home or from their office. So I would ask that you just treat it like you were in the appellate court. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. I will keep the time, and I have sheets of paper, since we don't have our light system, that I will hold up at 2 minutes, at 1 minute, and when time is up. So with that, I think we're ready to proceed. Attorney Sexton, are you ready to go?
I am, Your Honor, and there'll be no cigarettes today. Thank you.
Okay.
Good morning. May it please the court. My name is Attorney Jay Sexton with Sexton & Company. I'm here today as assigned counsel on behalf of the petitioner appellate, Francis Anderson. I'd like to reserve 4 minutes for rebuttal, please, Your Honor.
Okay, you're all set. Go ahead.
Thank you. Before I get into my argument, I want to enumerate 3 criminal judgments and 1 finding that was made by the Psychiatric Security Review Board, or PSRB, that will be discussed throughout argument. And I just want to, for purposes of clarity, make sure we're all talking about the same things. The first is a 2011 guilty plea conviction with a sentence that was set to expire in 2017. The second is a 2013 NGRI, or not guilty by reason of insanity, acquittal, which resulted in a commitment to the PSRB for a period of 10 years. The third is a 2014 PSRB finding that the petitioner had a psychiatric illness that required treatment and to be housed in a maximum security environment. Because if discharged, he would be a danger to himself or others. And finally, fourth, the 2016 guilty conviction for the Whiting assaults. So with those 4 different adjudications or findings in mind. The judgment of the habeas court should be reversed and the case remanded with direction that the respondent be ordered to credit the petitioner for the 750 days that he spent at Northern Correctional Institution as a pretrial detainee towards his 2016 sentence. The key to understanding why the petitioner was not double dipping on his sentence credit rests on three legs. First, and most importantly, there is a sliding scale of liberty interests that determine the petitioner's rights. Second, based on the differences in these liberty gradations, our Supreme Court and this court have previously concluded that the petitioner was a pretrial detainee who was being transferred from Whiting to Northern solely because he could not post bail. And third, even though as a matter of law, the petitioner was receiving credit against his 2011 conviction while he was at Whiting, he had a sufficiently significant liberty interest in the less restrictive hospital environment and attendant medical treatment that any transfer to a correctional facility required him to be treated as a pretrial detainee. And it was based on these three legs that the petitioner was offered bail in the first place, that the Supreme Court stated that his transfer from Whiting to Northern on a pretrial basis was due to his not posting bond, and the Supreme Court held that the petitioner went to Northern as a pretrial detainee, not as a sentenced prisoner. In short, the petitioner was never double dipping because the liberty interest that he lost by being transferred from Whiting to Northern was sufficient to treat him differently than in a sentenced inmate.
So let me just make sure, when you say he wasn't double dipping, what you're asking is that he get that 750-day credit against the 2011 sentence and also against the 2016 sentence.
No, Your Honor.
No?
No. And I'll explain why. I will explain why. So I don't want to be cute about it. Yes, I understand Your Honor's point. It certainly appears that way. But I think that the reason that's not the case is due to the understanding of these three different liberty interests.
Hold on a second. Attorney Sexton, his 2011 sentence, which was going to expire in 2017, he's already gotten the 750-day days credit against that sentence, right?
Yep.
Okay. And you also want that 750-day credit against the 2016 sentence.
Yes, but not for the same reason.
Forget putting the reason aside.
Yes, Your Honor.
You are asking for the net effect of him getting the credit twice.
Yes, Your Honor. And I still don't think that's double dipping for the following reason.
Well, whatever terminology you want to use, he's getting the credit twice under your analysis.
Fine.
Okay. Let me ask a question about his NGRI sentence. It was a 10-year maximum sentence, correct?
Yes.
So if he was determined to no longer be in the need of psychiatric treatment within the first year of his NGRI commitment, would he be released from custody and sent on his way?
Nope.
He would be sent back to DOC, right?
100%.
All right. So when you say in your reply brief that once he was sent to Whiting, he was no longer a sentenced prisoner, that's not accurate, is it?
I believe it is. And
why?
Because it goes back to these differences in liberty interests and gradations. When we think about the sliding scale of liberty interests, I want the court to conceptualize three different levels of liberty interest. The first is the ability to live freely in the community. The second is being committed to a psychiatric, being committed to the PSRB, and being detained in the Whiting Forensic Hospital.
Counsel, what I'm confused about is I understand that you are trying to create these very discrete status with respect to liberty interests. But isn't it true that the 2011 sentence is effectively hanging over him while he is serving his Whiting commitment? So when you say that he went to Northern not as a sentenced prisoner, that's only if you're looking at this very narrow idea of his, it's only in the context of this Whiting commitment. But the fact is he has this sentence that's still hanging that was effectively suspended and now re-triggered.
And that
really happening?
No, and there's a reason why the Supreme Court didn't treat it that way, and there's a reason why I don't think this court should treat it that way. The difference is that that analysis rests on the assumption that the only way you are not a sentenced prisoner is if it's the distinction between either you're free in the community or you're incarcerated or detained somewhere. And that is a false paradigm. The reality is that you have three different grades. You either have the living in the community freely, or you have a less restrictive environment being at a psychiatric hospital.
So when he was at Whiting, was he getting credit against his 2011 sentence for the time he was at Whiting?
Of course, Your Honor. But my point.
Wait, when you say of course, what it seems to me you want to do is take advantage of the restricted liberty interest to get him jail credit, but then say when that restricted liberty interest is taken away, or that liberty interest is not so restricted, that's when it's taken away, and put in something more restricted, he's entitled to additional credit.
And Your Honor, this is the Supreme Court. If you look at the 2015 State v. Anderson Supreme Court decision, specifically footnotes 37 and 38, they draw this very distinction that we're relying on. The Supreme Court was the one that indicated that he is a pretrial detainee. That's just not our argument. That is the the Supreme Court, and they predicated their entire due process analysis in their 2015 decision based on these very distinctions in liberty interest that I'm referring to. And so on the one hand, the difference between Whiting and a correctional facility are sufficiently similar that if an inmate is transferred to Whiting, they get credit for the sentence for which they were previously incarcerated. At the same time, what the Supreme Court makes clear in footnote 37 is that because you have increased liberty when you are an insanity acquittee at Whiting, you have a less restrictive environment, you have increased access to healthcare and access to the Patient Bill of Rights and all of that, that when you are deprived of that solely because you can't post bond, it doesn't matter that you wouldn't be going home. The fact that you're losing the liberty interest you have in being in a less restrictive medical treatment-based environment with increased access to healthcare and psychiatric treatment is itself sufficient to allow you to be treated as a pretrial detainee. And that is exactly why, on the one hand, Your Honors are entirely correct. And I understand that at first blush, it appears that this is classic double dipping. For the exact reason that both Judge Bright and Judge Elgo, you started your questions to me with, which is, yes, he's getting credit at the same time for different things. At the same time, the difference is that he would still have been in Whiting, which is a less restrictive environment where he has heightened liberty interests that are protected there, but for his inability to post bond. And both this court and the Supreme Court have acknowledged, and granted, this court was just quoting what the Supreme Court had said in 2015, have acknowledged that he was a pretrial detainee. Indeed, he would not have even been eligible for bail if he were a sentenced prisoner. In fact, the only way that bail would have made a difference if he were a sentenced prisoner is if the bail court had the authority to modify the 2011 sentence, which of course it wouldn't have had the authority to do. So their bail would have been moot. The reason he was eligible for bail, and by the way, if you look at the state's brief in 2015 to the Supreme Court, they even go through and they refer to him as a pretrial detainee. Up until this habeas, the Supreme Court, everyone else has been treating him as a pretrial detainee who was entitled to, had these heightened liberty interests, and who was transferred from Whiting to Northern solely because he could not post the $100,000 bail that was set for him. And so I disagree with the proposition that the only way that you get the pre-sentence credit is if the liberty interest you're giving up is your right to live in the community. So the fact that he would have had to go back to Northern anyway is irrelevant. He's giving up the liberty interest he had in remaining at Whiting. And so that's this distinction. On the one hand, as our Supreme Court has held in other cases, on the one hand, it is true that a correctional environment and the Whiting environment are sufficiently similar that an incarcerated inmate who gets transferred to Whiting does continue to get credit. No disputing that. At the same time, what our Supreme Court said, and in particular in footnote 37, I'm happy to share my screen and put footnote 37 up so that the court can see it. They talk very specifically about the heightened liberty interest that he has by being at Whiting. They talk very specifically about the constitutionally protected interest in the conditions of reasonable care and safety, reasonably non-restrictive confinement conditions, and such training as may be required to effectuate those interests. And
Counsel, but he doesn't have a choice. He didn't have a choice as far as being at Whiting, right? I mean, he was committed to Whiting. Does that make a difference?
I don't think so.
Have a choice?
No, and in fact, I think that part of the fact that he was adjudicated NGRI in 2013, and that the PSRB in 2014 made the required finding that he had psychiatric illness, and the further finding that he required confinement in a maximum security environment. Those are what helped to create these additional due process safeguards. So there, in fact, that's the very reason why the system doesn't treat this as think about it. If this were a usual situation, what would happen is that he would remain at where he was previously incarcerated, and the PSRB would just file a detainer saying when he's done serving his time on the 2011 sentence, send him over to us. But this is not a typical situation. Because he was found NGRI, because the board, the PSRB, subsequently found him to have a psychiatric illness requiring maximum security confinement, he had a right to these additional liberty interests in terms of the less restrictive means, in terms of the heightened right to medical and psychiatric treatment and care. And when, as a result solely of his inability to post bond on the 2016 what became the 2016 conviction, but when that was the sole reason that he got sent to Northern, that triggered the very clear language under General Statutes 1890 AD, because and both the Supreme Court and, as a result, this court have previously said that the only reason he was transferred was because he couldn't post bond that he would never have been eligible for if he were being treated as a sentenced inmate. And the pinpoint sites for that are in State v. Anderson, 319 Con at 297. The majority says because the defendant was unable to post that bond, he was transferred to the custody of the Commissioner of Correction. And in the dissent, which was at 327, the dissent said, quote, The court imposed a monetary bond in the new case, and the defendant was transferred to the custody of the Commissioner of Correction because he could not afford to pay that bond. The only reason he went to Northern rather than remaining at Whiting was because he couldn't post the bond. Thank you, Your Honor.
All right, you'll have 4 minutes for rebuttal. Attorney Medeiros? You're on mute.
Thank you, Your Honor. I apologize. Good morning, Your Honors, and may it please the court. My name is Assistant Attorney General Janelle Medeiros, and I represent the respondent appellee, Commissioner of Correction, in this appeal. This court should affirm the decision of the trial court because the trial court did not abuse its discretion in denying the certification appeal, as it's well established that sentenced inmates may not receive pre-sentence credit while they are serving a sentence. And despite petitioner's recent arguments to the contrary, it's undisputed that the petitioner was a sentenced convicted prisoner during the entire period for which he now seeks pre-sentence credit. In fact, it's undisputed that petitioner at all times since 2008 until the current day today, petitioner has been a sentenced convicted prisoner at all times throughout that time period. So specifically, Mr. Anderson seeking 750 days of jail credit for the time period between August 25th, 2014 and September 12th, 2016. But again, he was a sentenced inmate during that entire period. And as this court unequivocally has held, and the Supreme Court has unequivocally held in King, Bernstein, Therese, Steve, Graham, Washington, Harris, Hunter, Cox, and the other many cases that we've cited in our brief at pages 8 to 9, sentenced prisoners cannot earn pre-sentence credit for time that they are serving a sentence. And the reason for this, as Judge Bright very aptly noted, is that inmates shouldn't be permitted to double dip or double count days towards more than one sentence at any point. And the petitioner in this case is really no different in any material way from the petitioners in this long line of cases that we've cited. Now, the petitioner fails to address this long line of cases at all, and he seems to try and get around these cases by urging the court in his reply brief to determine that the petitioner was, in fact, not a sentenced prisoner in August 2014 because he had previously been found NGRI earlier. As Judge Elgo, or as Judge Bright noted, it is not accurate that Mr. Anderson was not a sentenced prisoner during the time period for which he seeks pre-sentence credit. There's just no authority to support the proposition that a finding of NGRI somehow invalidates prior convictions, somehow vacates these prior sentences, the 2008 sentence and the 2011 sentence, which were running consecutively at the time he was found NGRI. There's just no authority to suggest that it's appropriate for the finding of NGRI to somehow erase those prior sentences. And in addition, I mean, the petitioner has argued that at all times, everyone has referred to Mr. Anderson as an unsentenced inmate, that the Supreme Court referred to him as a pretrial detainee, that the petitioner has and the state have repeatedly referred to him as a pretrial detainee. But this characterization of the petitioner as an unsentenced prisoner really runs directly contrary to the petitioner's own submissions before the trial court. The petitioner repeatedly conceded in his petition, in his brief below, and before the trial court that Mr. Anderson was a sentenced prisoner during this time period. This court also acknowledged that Mr. Anderson was a sentenced prisoner when he was sentenced for the Middletown charges in 187 Con-App 585, the appeal before this court regarding the correction of his illegal sentence. This court noted that he was a sentenced prisoner, and his own defense counsel noted at his sentencing on the Middletown charges that he was a sentenced prisoner. Yes, Your Honor.
So, Attorney Medeiros, let's take a hypothetical where there's not the 2011 sentence. So if Mr. Anderson was simply at Whiting as an NGRI, and while at Whiting he is accused of committing assaults, and a bond is set, and he is moved from Whiting to Northern, and he served 750 days there before he's found guilty, would he be entitled to that 750-day credit as a pretrial detainee?
Well, if Mr. Anderson didn't have the prior 2008 or 2011
Correct.
sentence, yes, Your Honor, he would be. He would be a pre-sentence inmate at that point. And I think the important distinction here is not whether he was a pretrial detainee or not. It's was he serving a sentence, because he was absolutely a pre-sentence inmate on the Middletown charges. And that's what the Supreme Court was acknowledging in the 2015 case regarding bail. He certainly was pending sentencing on the Middletown charges, but that doesn't erase his prior sentences. He still had the 2005 and 2008 and 2011 sentences, as Judge Elgo noted, hanging over his head at that time. They didn't go away. Although when we look at him just in the context of the Middletown charges, he was pre-sentence. But that's the same position that the petitioners in Therese and King and Bernstein and all this long line of cases are. They're pre-sentence on new charges, but they still have an earlier sentence, and they can't earn pre-sentence credit when they have an earlier sentence. It's the same situation here. And that's kind of the problem with the petitioner's other argument. I mean, it is accurate that 18-98D provides that there's this, if they are confined in a correctional institution because of inability to post bail, there's that part of the statute. And it's absolutely accurate that at that particular time, Mr. Anderson was transferred to Northern because of his inability to post bail. But as Your Honor noted, he could have been transferred to DOC to Northern for other reasons. For example, if he had appealed his commitment to Whiting and that commitment had been vacated, he could go back to DOC. If the PSRB had determined that he completed his treatment, he could go back and he no longer needed to be confined. He could get sent back to DOC by virtue of a court order. Of course, that didn't happen here, but he still would have had to go back to DOC. It's no different than a prisoner who perhaps is in federal custody while also serving a state sentence, or perhaps gets transferred to Virginia and picks up new charges down there and then comes back. There's no difference here. But in addition to that, the 18-98D provides that pre-sentence credit cannot be applied unless the sole reason for confinement is the inability to post bail. And the sole reason for Mr. Anderson's confinement was not the inability to post bail. Mr. Anderson was confined, and the state had the legal ability to hold him for several reasons, because he was previously sentenced on the 2008 and 2011 convictions. So the DOC had legal custody of him, although they didn't have physical custody of him at the time. And he also was serving his period of commitment, so DMIS also had legal custody of him. So there's several different reasons why he was confined at the time. The sole reason was not the inability to post bail. And so the trial court aptly noted that the transfer to Whiting was really a red herring because it's irrelevant to the analysis under the statute. The transfer to Whiting didn't alter the petitioner's status as a sentenced prisoner, and it didn't erase his prior convictions, as he urges this court to find. Ultimately, the petitioner can't point to any legal authority, and none exists, to suggest that a sentenced prisoner can receive pre-sentence credit when he has already received day-for-day credit for the same period of confinement. At all times from 2008 until today, petitioner was and still is a sentenced prisoner, and therefore he's not entitled to jail credit. For these reasons, as articulated more fully in our brief, the trial court did not abuse its discretion, and this appeal should be dismissed.
All right, I don't see any questions from the panel, so Attorney Sexton, you'll have 4 minutes.
Thank you, Your Honor. Let me just begin by saying that this case presents a question of first impression. None of the cases that are relied on by the respondent in any way address the factual scenario that we have here. Not one of them. In fact, many of them were even before the 2015 State v. Anderson Supreme Court case, which held him to be a pretrial detainee, and it is mutually exclusive. You are not both a pretrial detainee and a sentenced inmate. Either you are a pretrial detainee in the sense that you are entitled to bail, which a sentenced inmate is not, and that you would be entitled to pre-confinement credit, which a sentenced inmate would not, or you're not a pretrial detainee, you're a sentenced inmate. And I would suggest to the court further that there is a huge difference between someone who is being detained, whether it is at Northern or a correctional facility in a different state. Anyone who is in a correctional environment is in a very different situation than someone who is in a psychiatric hospital where they have these heightened liberty interests. I think that this is the type of, frankly, I think this case is going to end up back at the Supreme Court because this is a question of first impression, because it would be incongruent to say, on the one hand, our Supreme Court has said that you're a pretrial detainee entitled to bond in the first place and that you have these heightened liberty interests, but because you could still end up back at Northern in some sort of super speculative set of circumstances that aren't at play here.
So, Attorney Sexton, if someone is serving a sentence that is a 60-day sentence, and while they're serving that 60-day sentence, they get charged with a murder, can the court set bond on the person, recognizing that their 60-day sentence is going to expire before they go to trial on the murder charge?
I suppose hypothetically they could, but the prisoner would not. The prisoner would remain in custody until the end of the sentence, at which point then it would be a question of whether he could post bail. But right. I think that's very different here, where you still have the immediately loss of the liberty interest. It's not the situation where it's either you're going to be at home in the community or you're going to be detained. The Supreme Court has drawn a distinction between you still get pretrial confinement, you still get the pretrial credit if you're giving up the liberty interest that you have in the less restrictive environment at Whiting. This is just simply not this black and white case. The statute 1898D simply does not contemplate this exact situation. It's why no one is able to provide you a case that is directly on point. You have the fact that, as the respondent concedes, the text of the statute strongly suggests that that Mr. Anderson is entitled to the credit. Moreover, you have the Connecticut Supreme Court, who, based on a due process analysis, treated him specifically as a pretrial detainee who was going to have a less significant period of incarceration as pretrial than he would as a sentenced inmate. That's inherent in the Supreme Court's analysis. I don't know how this court can reconcile the Supreme Court's analysis in its 2015 decision with the idea that he didn't give up any loss of liberty that entitles him to this additional credit.
All right. Thank you both for participating in the virtual courtroom today. We appreciate your efforts to get the technology squared away. We look forward to seeing you both in our physical courtroom in the near future. We will take the matter under advisement, and we will stand in recess until 10:30 this morning. Thank you both. Have a good day.
Thank you, Your Honors.
Thank you.